Lady, good afternoon. Before I take you to the overseas authorities and the world of the Rule Committee, both of which I promised to do this morning, can I just pick up on three of the points from this morning? First, my Lord Sells was asking about the wording of Rule 32.13 and about the judge court directing during the course of the trial. This is for evidence in chief. And at page 125 in our printed case, paragraph 23, we explain that that wording was clarified from wording that you'll see on 125 in paragraph 23 that had said witness statement that stands as evidence in chief is open to inspection unless the court otherwise directs during the course of the trial. Problem with that is it suggested it was going to be open-ended, and it was amended, and the amended wording you'll find at 3725, but you'll see it there in our printed case. A witness statement which stands as evidence in chief is open for inspection during the course of the trial unless the court otherwise directs. So an added emphasis on the fact that you deal with it there and then, we say, tightening up of that wording. Secondly, my Lady Hale asked me about the family court position. What we've been able to get to so far is that the family division practice is that the trial bonds are to be collected within 5 working days. Otherwise, they are liable to destruction. It's practice direction 27 capital A at 9.1. But it does also say there are local arrangements for electronic bundles. And it would be right for us to look further to see if there's any rule like the insolvency type rule about how you compile it. My submission on necessity and proportionality, which we were dealing with just before we broke.
But that would be within 5 working days of the completion of a hearing, or within 5 working days of the completion of the case?
Completion of the hearing.
Thank you.
The open justice principle, necessity and proportionality, what I've shown you is that the open justice principle can attract a necessity and proportionality test when you are examining rules. And that was the D case at page 6355, paragraph 198, the parole case. And as you know, so can the access to justice principle. That's unison at paragraph 88, and that's page 3189. Now, why is that appropriate here? It's because I am saying that the rules are comprehensive and meet the open justice principle. And that's the proposition that we have to test. And the way to test that proposition, we submit, is by asking, is there an unjustified interference? If that is right. And if there isn't an unjustified interference, you don't need an inherent jurisdiction. There isn't a justification. You don't have to read it in. You are, in effect, adding it on. But the submission is that the rules are a comprehensive code dealing with...
I thought you accepted that they weren't, at least in relation to skeleton arguments.
I do accept that for skeletons, because there is a gap.
So how do we tell when there's a gap?
There's no gap for witness statements, because you've got express parameters about how you can access them. There's no gap for enduring access to documents from the court, because there's an express rule. If you're against me on that proposition, then it's still a necessity test for all the reasons I've developed in relation to, firstly, the inherent jurisdiction and how it operates, and we'll see in a moment from New Zealand a helpful authority, and also because we are talking about a functus situation after a final determination. Now, the court had, from the intervener, a citation of a New Zealand case. You've got it in a different version, I hope, on your desks. And the reason for that is that they mistakenly included the Court of Appeal decision when they were in fact citing the New Zealand Supreme Court. So hopefully somewhere you've got Mafat in the Supreme Court of New Zealand, and if you haven't, I'm sure we've got further copies. I know it was handed up first thing this morning.
It's been emailed as well.
Has it? Thank you.
Which I hope is...
Put it loose.
Yeah.
Let me tell you what you're about to see, because this is the Supreme Court of New Zealand in 2006. What we're about to see is that the open justice principle in New Zealand informs the application of the rules. So the rules regulate, and then how you apply them is informed by open justice. Now that is conceded by the respondent at paragraph 109 of their printed case, when they say that in New Zealand it's the application of the rules. So that's page 193, and the quotation they give from a case called Rogers at paragraph 109, fourth line, administer the rules on the basis that. So not expand them or replace them or add to them. And we've made our submission that 5.4c is operated by reference to the default position in Guardian. The second thing we'll see is that court record and court file are documents constituting an archive in accordance with practice, and there's quite a helpful discussion of all of that. If we look at Mafat then, which was a case about videotapes, which, pursuant to a statutory duty, see paragraph 3 at the bottom of the page, had to be sent to the Registrar of the High Court, top of the next page, to be preserved. So that's the context. Paragraph 7 then tells us public access to court files must be considered in the context of various things, of which open justice footnote 11 is one. And then if we turn on, you'll see it, paragraph 14, heading the jurisdiction of the High Court. And at 16, the adjectival jurisdiction and powers of the High Court, to give effect to its substantive jurisdiction, are part of the general jurisdiction. They derive from the practice of the English courts based on the inherent jurisdiction. Except to the extent modified by statute and rules, the court continues to have inherent jurisdiction and powers to determine its own procedure. Inherent jurisdiction is not ousted by the adoption of the rules, but it is regulated by the rules so far as they extend. And 17 at the bottom of the page, where rules do not apply, the inherent jurisdiction can be invoked by a judge to regulate or adjust the procedure to give effect to the interests of justice. Footnote, very bottom of the page, GIO, skeleton arguments from the United Kingdom. If we, just continuing this first theme about the open justice principle and the inherent jurisdiction, go on to paragraph 20, you'll see the court is discussing records that remain under the control of the court by reason of its inherent power to control its processes and practices until disposed of, according to the practice of the court or legislation. Then this, where rules of court provide for access to court records, the inherent supervisory power is regulated by the rules. Footnote 41 is a case called Philpott. We know that case as Chan You Seek, and I'll show you it. That's the case that says no inherent jurisdiction, because the rules occupy the field, and the New Zealand Supreme Court is citing it. So that's paragraph 20, and then if you flick on, 23 and 24, 23, a general right of access would be inconsistent with the scheme of the rules adopted to regulate access. And then a quotation saying there's no common law right of access to court documents. The United States has gone in a different direction. That's the quote at paragraph 23. And then this at 24, before there were rules, no rules have been made to regulate the inherent judicial control of access to court records. And so in those circumstances, you had the inherent jurisdiction, and then the court tells us at 25 what the rules now are and what their parameters are, and it summarises them at 26. So that's theme number one. It's application of the rules that regulate the position, albeit it's informed by various features, including the open justice principle. The second theme I said was about court record and court file. If we go back to paragraph 18, there's a heading access to records of the court. And then we get the historical picture about courts of record maintaining records as a significant ministerial obligation. The record is conclusive of matters formally entered. So that's what the court generates. The maintenance of the record is a matter of practice carried out by registrars acting for the court in this ministerial work. And then statutes, paragraph 19, may prescribe, we've seen it in insolvency, what's to be on the record. Middle of that paragraph, to a substantial extent, the content of the record is not prescribed by enactments, is a matter of the practice of the court. Then if we go to 21, we've done 20 already. 21 then explains there's a difference between those formal the record of the Court of Record and other material received by it during the course of proceedings and held on the court file. Such records are conclusive as to essential court processes and the outcome of proceedings. They constitute the formal record. The file will also include documents, exhibits which may remain the property of the parties, and other material which constitute an archive generated by the proceedings which are not the formal record of the court. So you get the idea of Court of Record has a record of what it generates, then you get the idea of a court file which has certain documents as a matter of practice which constitute an archive. And I'm happy to accept that you look at the court file, the archive, what is generated as a matter of practice, not what just the documents that the court itself generates as a record, but what, as an archive, it retains as a file. And you've got our submissions so far as that is concerned. Now, following the New Zealand Supreme Court decision, there was then a New Zealand Law Commission report, of which you have an extract only at page 6963. It's about 125 pages long, and it's talking about new rules and expanding the record in the context of the open justice principle. So if you have on your machines 6988, for example, you will see at paragraph 2100 in the conclusions of what is only chapter 2 of that Law Commission report. Open justice is a cornerstone of the New Zealand justice system, should be a key guiding principle in an access to court information regime. 6988.
6988?
Yes, 6988, paragraph 2.100. First three lines.
I'm sorry, I'm having trouble with 6988. Oh, I know. Yes, it's entirely my fault. I'm
so sorry, my lord. It's the bottom
email.
paragraph on 6988, and they then make recommendations at the bottom of the next page, 6989, about the principles that should underpin, in the shading, access to court record rules. And New Zealand demonstrates not only how a principle informs the application of rules, but how you can reevaluate your regime through a Law Commission report that then leads to new rules. The new rules start at 5070 for the senior courts and deal with the court file and the formal record and documents. And just 2 quick points from it. 5072, you will see this is now the legislation in New Zealand for the senior courts. And the legislation distinguishes between court file, about 7 lines down at the top of 5072, and document. And document, about 10 lines up from the bottom of 5072, means any written material in the custody or control of the court relating to proceedings, whether or not it is kept on a court file. That's the point. That's the distinction. As I said earlier, if the rule had meant you can get from the court what the court has in its custody and control, then it would be...
But I mean, the documents in our case would satisfy the definition of court file here, wouldn't they? The documents that were in the custody or control of the court?
No, because if you see in the definition of document, it's written material in custody or control, whether or not it's kept in a court file. So court file is a subset.
Yes, but what I was putting to you is, according to this code, the material in Bundle C, which was at all times in the custody of the court, would qualify as the court file, wouldn't it?
No, because it's not kept on a court file. It's written material in the custody or control of the court. You have to read the two together, otherwise they are
But sorry,
identical.
that is the definition of a court file.
Yeah, but I'm showing the definition of document. Written material in the custody or control of the court, whether or not it's kept on a court file. So that is wider
Whereas court file means a collection of documents in the custody or control of the court that relate to a civil proceeding or a criminal proceeding, blah, blah, blah.
Right. But what I've just shown you is that...
One is kept and one isn't, I think.
But on the facts of our case, as I understand it, the documents in Bundle C were always kept in the custody or control of the court.
Right, and that would make them documents.
Well, it also makes them a court file, doesn't
Yes.
it?
No, because the broader can't be swallowed up by the narrower.
The court file has to be a collection, so there has to be something grouping them together.
And the second thing is just to pick up on something that's misstated in one of the printed cases. If you look at the bottom of 5079 in the New Zealand rules, the approach to the balancing says that if you're wanting access B during the substantive hearing, open justice has greater weight than at other stages and greater weight is given to documents relied on in the hearing. But after the substantive hearing, open justice has greater weight in relation to documents that have been relied on in a determination than other documents, and that's been mischaracterised. So in fact, it's interesting to see where the weighty consideration is. It reflects what I was saying earlier. If we go to New South Wales, to page 4442, the court is now in a case called John Fairfax Publications. And if you look at paragraph 35, the Supreme Court of New South Wales is explaining that the rules for access to documents from the court record were inapplicable. There was no express provision that covered what was being sought. They then refer to the test of necessity, paragraph 39, in the context of whether there is an inherent jurisdiction, and conclude at the bottom of 4443, 5 lines up, however desirable it may be to serve the objectives of the principle of open justice, it cannot be said to be necessary in order to do so. So that supports you need to satisfy a necessity test. And if you just go back, please, to page 4440, the court, the Chief Justice, explains at the bottom of 4440, neither the claimants nor the public at large have a right of access to court documents. The principle of open justice is a principle, not a freestanding right. And at the top of the page, it remains a principle and not a right. Finally on this, because it is rather helpful in drawing a lot of themes together, if you go to 4445, the principle of open justice is a fundamental axiom, paragraph 60, but it's pertinent to recognise that it has purposes related to the operation of the legal system. And at the bottom of the next page, 4446, the court gave the claimants access to the fact of the complaint, the fact of the consent, and terms of the order. The purposes to be served by the principle of open justice were fully and completely served by this disclosure, no matter relevant to an understanding of what the court actually did was withheld. Everything necessary for the public to scrutinise the process itself was made available. So that's back to the reasonable observer and whether there is something that cannot be understood. I haven't got time to go elsewhere in the world, but Canada has a common law right which is regulated under rules, and South Africa has constitutional court authority that is dealing with the records of the court, which takes us back to the records of the court. I just want, while I'm sure I still have time, to do Chan Yu, because we just saw it referenced by the Supreme Court in New Zealand. And if the court please looks in the authorities at page, forgive me, 1180 is where Chan Yu begins.
I beg your pardon, which page again?
1180.
Thank you.
And this was a case that had settled after a trial, C1182, paragraph 1. This was a case where the bundles had been collected. And the Guardian make an application for various things, see paragraph 7 on 1183, and the basis of their application, 3 things, end of paragraph 6 on 1183, 3213, so witness statements, inspection, 5.42c, records of the court's inherent jurisdiction. At the hearing, they rely on records of the court. That's paragraph 13 on 1184. But the judge, Mr. Justice Park, wishes to make observations about the others. He then deals at 14 and 15 on 1184 with the witness statement inspection rule and says it can't, at letter B on 1185, there's no tenable reading to say they can still rely on that. He says, but there are other powers, and he means the records of the court powers at letter C on 1185. Inherent jurisdiction at 16, and bear in mind New Zealand Supreme Court cites this authority in relation to the inherent jurisdiction. Hard to see the inherent jurisdiction taking it any further than 5.4. Then this, where there are 2 specific provisions identifying circumstances in which the court can order disclosure of documents, but neither applies in a particular case, I find it very hard to imagine myself nevertheless invoking inherent jurisdiction, the limits of which are nowhere set out with precision in order to direct disclosure. After all, the application is therefore based solely on 5.4, and he goes on then to deal with paragraph 18 on 1186, what is or isn't in that case in the records of the court. End of paragraph 18, trial documents are not part of the records of the court. Now, in terms of the committee, you've seen from our skeleton argument that there are no fewer than 5 subcommittees of the Rules Committee that have looked at open justice, records of the court, witness statement inspection, and so on. May I give you some references? The Civil Justice Review 3591-2, 3597-8. That's in the light of witness statements now standing as evidence in chief, they should be open to inspection for a limited period. That was the Civil Justice Review, driven by the open justice principle. You've seen the arrangements that led to. The Jackson Working Group of 2004 considered records of the court access following the GIO case. And it's at 3752 and 3747. And they amended the rules to introduce the new Register of Claims, but that was it. 3770, and that was following a consultation, 3767. There's then in 2006 a new version of 5.4, the records of the court provision, 3841, after consulting the press and others, 3851. And it's made prospective only by an amendment, which my Lord Briggs may remember, because there had been a judicial review by the Law Society, because it had expanded to include statements of case. Then we had the Jackson Subcommittee on Access to Court Documents in 2008, 3863, to include a member of the press on the committee. They then report 3865, and they report on all 3 key features: records of the court, paragraph 2.3, witness statements, paragraph 2.5, skeleton arguments, paragraph 2.6. And the only change that's needed is a rule in relation to skeleton arguments in the Court of Appeal, which then becomes part of Practice Direction 52, 3925. The Henderson Committee then looks at public hearings in 2012, and there's an open meeting of the Rules Committee, open to the public, 3911, all in 2012. That topic is subsequently picked up by the Kerr Subcommittee in 2017, 4127, and they consulted last year on open justice and in particular CPR 39. But in between those two, and this is the one I want to show you, the Richards Subcommittee in 2015 does a consultation exercise, and we find this at 3920. 3920. It starts at 3919. The subcommittee is set up, and this is its original paper in April of 2015. The committee is described at 3919, paragraph 2, and it's doing this in the light of Guardian. See paragraph 3, Guardian in the Court of Appeal. This is then a report of representations that have been made to the committee, and the relevant documents are described at 3920, end of paragraph 4. So, press and others say access is needed to the following classes of document: claim forms, particular claims, notice of appeal, skeleton arguments, judgments under appeal, and witness statements. 5. It's clear from the representations access is sought for the purpose of informed contemporaneous reporting. What they need is for relevant documents to be available at the beginning of a hearing. They then discuss Rule 5.4c, see page 3921, at paragraph 11, and the inspection of witness statements, paragraph 12, and they say at the bottom of the page, paragraph 13, that that may be thought to deal sufficiently with access to witness statements. As the court said in Guardian, where there are reasons against access and proportionality, access will be carried out by the court. So that's witness statements. And then paragraph 17 is skeletons in the Court of Appeal that leads to the rule change in the light of what's being said by the press. The responses were all summarised in a summary document that Lord Justice Richards then compiled at page 3946. So they're responding. What documents are needed for open justice in this context? Association of Lawyers for Children, 3946. Then the Bar Council, 3947. Chartered Institute of Legal Executives, and so on. News Media Association, the interveners in this case, at 3949, welcoming the provision of skeleton arguments before the Court of Appeal. And then at 3950, 3 paragraphs from the bottom, witness statements must remain available and open to inspection. Well, that's the rule. 3950, 3 paragraphs up from the bottom. There may be a need for access after the proceedings in order to ensure accuracy of reporting and to facilitate understanding and analysis at that stage. And the Strand News Services Limited make a similar point in the middle of the next page. So the Rules Committee gathers all the representations about these rules and their design, and they come to the conclusion in a report at 3933 that the system is working well and that what is needed is skeletons in the Court of Appeal. That report, which I haven't got time to go through, is at 3933. They've consulted, they've had the responses, and they deal with mechanics, bottom of 3934. They deal with the court file, paragraph 8 on 3935, and they identify what's needed in the recommendation at 3938. So, unsurprisingly, we have a Rules Committee well aware of Guardian and the open justice principle, obliged to consult as they are under the statute, who have reviewed the operation of all of these arrangements. And whether or not this court would wish the committee to look again, we do submit that this court should be extremely slow to conclude that what has been decades of practice under carefully crafted procedures needs to be replaced with what will be a revolution and one which is unruly given the absence of rules and parameters and clarity and policy choices and resource implications, and simply puts former parties in the firing line to be the subject of satellite applications and reconstruction hearings in the case of parties who could perfectly well have availed themselves of the safeguards deliberately built into a system within the framework of rules. Anything else? Unless I can assist you further at this stage with any questions, those are our submissions in support of our appeal.
Well, you were bombarded before the short adjournment, but you seem to have emerged relatively unscathed.
Well, let's see.
Thereafter. Yes. Thank you, Mr. Ford. Mr. Webb?
May it please your ladyships and your lordships. Can I start by making one introductory submission relating to the state of the law if CAPE submissions are correct? And then can I go through the structure of our written case? And we set out the 7 issues at paragraph 13, which is at page 168. And I will try to follow those almost entirely faithfully. So far as concerns the state of the law per CAPE's case, which they submit orally today, faithfully achieves the open justice principle, CAPE would have this court impose jurisdictional limits as follows. First, the trial documents, and I've defined those at paragraph 1 of our case, so I won't go back to that, fall out with the scope of CPR 5.4c2 and so cannot be obtained on that basis. Secondly, only skeleton arguments can be obtained under the inherent jurisdiction of the court. Thirdly, the application for such skeleton arguments has to be made during the trial. And even then, the forum's interest, certainly per what's set out in writing, haven't heard much about it today, is not a legitimate one, so it cannot even obtain the skeleton arguments. So if the forum had attended during the course of the trial, it could have obtained access to witness statements under 32.13 of the Civil Procedure Rules. Subject to what I'll say in a moment, the court would have had no jurisdiction, whatever the forum's interest, to provide disclosure documents at all, even though deployed at trial, relied upon and referred to in court, open court. And I now highlight 2 quirks of CAPE's case, which do not sit well with their reasoning. The first is that it submits that the Civil Procedure Rules contain a full code which provides carefully managed rules under CPR 39, hearings in open court, under 31.22, which provides litigants, but litigants only, with the right to make use of documents that have been relied on in court. 31.13, which is the witness statements provision that we've seen, and 5.4, which they say takes the case nowhere beyond effectively statements of case. Yet they accept in writing, this is paragraph 75 of their case at page 162, that the court retains the power under the most general provision in the civil procedure rules, namely CPR 1, to allow inspection of documents at trial. There is the most carefully contained set of express provisions dealing with the matters, and yet CAPE itself is constrained to recognise that CPR 1 can be prayed in aid by a non-party, certainly during the course of a trial. And the second quirk is that CAPE submits that there is no room for the application of the inherent jurisdiction of the court because it would cut across the civil procedure rules, which are created and updated, as you've just heard, by the Civil Procedure Rules Committee. Yet, it accepts that there is an inherent jurisdiction to provide access to skeleton arguments, because it says GO was rightly decided. And that's even in circumstances where the civil procedure rules do speak to access to skeleton arguments in the Court of Appeal. There they are to be provided to members of the press. So we have another example of there are specific rules dealing with skeleton arguments, but we don't hear the argument being maintained, at least consistently, that because it's spoken in relation to the Court of Appeal, it must have been silent for a reason in relation to ordinary trial skeleton arguments. Well, Lady, I hope to show that CAPE's case is unsustainable as a matter of principle, that it imposes an unwarranted fetter on the open justice principle, and that it's inconsistent with a wealth of authority in this country, not least the Supreme Court decision in Kennedy in 2014, which makes no appearance in CAPE's arguments, written or oral. My lady, can I then turn first to the principle of open justice? And here, my lady, I propose to address two issues. The first is to emphasise the breadth of the rationale for the principle of open justice. And the second is to make outline submissions as to why it is that the court should ensure that it has the power to provide non-parties with access to trial documents referred to in the course of proceedings in open court, whether that application is made during or after a trial. My lady, on the first case of the broad rationale for the principle of open justice, our case is set out in writing at paragraphs 14 to 24, and may I simply make these two submissions. The first is that the principle of open justice is not a mere procedural rule. It is a fundamental common law principle, an aspect of the rule of law in a democracy. Now that's in part a quote from Lord Dyson in Al-Rari at paragraph 11, and in part a quote from Lord Reid in A against BBC at paragraph 23. And may I take your ladyship to those cases? My lady, the Al-Rari case you'll find at page 1274. My lady, paragraph 11 was put in support of a submission that the open justice principle is a procedure rule. What Lord Dyson actually says is the open justice principle is not a mere procedural rule, it is a fundamental common law principle. And Lord Reid at page 1505 paragraph 23 at the top, under the heading, the general principle of open justice, says it's a general principle of our constitutional law that justice is administered by the courts in public and is therefore open to public scrutiny. This principle is an aspect of the rule of law in a democracy. Now, whilst those statements are well known to this court. They need emphasis when it's recalled that Cape's case invites this court to cut down, as a matter of jurisdiction, the application of the principle of open justice. Ladies, secondly, can I go to the rationale for the principle of open justice, which I'm going simply to summarise in this way, that it concerns the related themes or values of transparency, accountability, inviting public scrutiny, and maintaining of public or maintenance of public confidence in the administration of justice. Lady, we've referred in our paragraphs that I've identified in our written case to various authorities in support of those propositions, and I'm not going to rehearse those. For these purposes, can I simply draw attention to the following? The courts are an organ of the state, or as put in Section 32 of the Freedom of Information Act, they're a body exercising the judicial power of the state. That's page 3421. I will go to Section 32 of the Freedom of Information Act in due course. Judges are not accountable directly to members of the public through elections, nor are they accountable to Parliament. The need for transparency in relation to the administration of justice is therefore intense. Lady, transparency is the means by which the civil justice system is held to account in a democratic society.
Well, not just the civil justice system, presumably.
My lady, not just the civil justice system in this case, but the
But it happens to be in this case, but we've got to look a little bit more broadly than
completely, my lady. The justice system. Thank you. And my lady, finally on this point, I'm going to quote from Lord Sumption in the case of Cuja, and the quote's at paragraph 13, and it's at page 1556b. It's paragraph 13, it's near the top, and it's at B. And Lord Sumption, having identified, you can see on the previous page, what he calls the law, in which he then addresses the principle of open justice, continues in paragraph 13. Its significance has, if anything, increased. Does your ladyship have that? In an age which attaches growing importance to the public accountability of public officers and institutions and to the availability of information about the performance of their functions. So it's malleable, or protean, it moves with the times, and its importance has increased, if anything, and certainly not decreased. My lady, on a second issue, which is why the open justice principle requires the court to have the jurisdiction to provide trial documents to non-parties. And here I'm taking our case slightly out of turn because we addressed much of what I'm going to say for your record at paragraphs 80 to 94 of our case. I'm not proposing the court goes there, but it's pages 186 to 190. But I hope it's helpful to address this head-on now at this early stage because it lies at the heart of the appeal. Why is it that these documents should be accessible? Lady, can I make 5 related submissions and then briefly refer to the cases of Guardian News and Kennedy? First submission is that the rationale to which I've already referred immediately invites public access to the evidence relied upon in open court. Your ladyship will forgive me, this point was captured by my Lady Hale in the case of the Queen on the application of C against the Secretary of State for Justice, at paragraph 1, which is at page 1523. 1523. I invite the court, please, to turn it up. It was an anonymity order case in which my lady gave the only judgment of the court as we see from 1523. And can I simply start, but I don't need to end, paragraph 1. Now, the principle of open justice is one of the most precious in our law. It's there to reassure the public and the parties our courts are indeed doing justice according to the law. In fact, it has two aspects to this principle. The first is that justice should be done in open court, so that people interested in the case, the wider public and the media, can know what is going on. Can I emphasize that word? The court should not hear and take into account evidence and arguments that they have not heard or seen. Transparency puts currency in knowledge per se. My lady, can I also take the court to what Lord Carnworth said in Kennedy at paragraph 240, which is at page 1475. This was in a dissenting judgment, because Lord Carnworth did not agree that it was not possible for the applicant to obtain the information, the document he sought, a report, under the Freedom of Information Act. He addresses this issue, I'm at page 1475, paragraph 240, but he addresses this issue under a heading at the previous page above para 234, the common law alternative. Then if we go back to paragraph 240, second sentence, the foundation of the Guardian News decision lies in the strong constitutional principle that courts sit in public. It is no surprise that the starting point of Toulson LJ's judgment is a quotation from the great case Scott and Scott, in which that principle was set in stone. It is not a large step from that principle to hold that papers supplied to the judge for the purpose of an open hearing should in principle be made available to the public, absent good reasons to the contrary. Lady, the second submission is that once a document is referred to in open court, it loses its confidentiality and enters the public domain. At that point, there is no good reason, prima facie, to withhold access to it. See here the dissenting judgment of Lord Scarman in Home Office and Harman. That was the case that led to Miss Harman's application to the European Court of Human Rights, which was then compromised, leading directly to the introduction of what became CPR 3122. And the recognition that once a document is set out in 3122 has been read to or by the court, this is a quote from 3122, or referred to at a hearing which has been held in public, then the litigant, because that was concerned with the litigants, can make full use of the document, subject to the court holding otherwise under 3122 brackets 2. My lady, can I ask the court to go to page 1134, E to F. I'm going to pick it up in the middle of that paragraph at E. Once, does your ladyship have that? Mm-hmm. Once they are public knowledge, freedom of comment concerning them inures to the public at large, it is further not disputed that once documents have been read aloud in open court and are not subjected to any specific lawful direction prohibiting publication, such as is envisaged as within a court's power by this House in Attorney General and Leveller, they enter the public domain. They are no longer confidential. Privacy has been stripped from them. And to similar effect, if you go over the page to 1135 at C, once the litigant's private right to keep his documents to himself has been overtaken by their becoming public knowledge, we can see no reason why the undertaking given, and that's the undertaking of confidentiality when you engage in mutual disclosure during the course of litigation between the parties, given when they were confidential, should continue to apply to them. Now that test, under 3122, is mirrored by Lord Justice Toulson in the default position that he sets out at paragraph 85, which is in our respectful submission exactly as it should be, because once a document is in the public domain, a member of the public, as much as a litigant, should have an equal level of access to that document. It's access to all because it's public. And of course, the court retains a discretion to withhold the document or documents. That is the case under 3122, it's the case under CPR 5.4C2, and it's undoubtedly also the case under the inherent jurisdiction of the court. So if there was some pressing reason why the document should nevertheless not be disclosed, the court retains that power. Lady, thirdly, the reach of the courts should extend to documents referred to in the course of open proceedings, whether or not read out in open court, to permit members of the public to know and understand how justice is being administered. Whether or not they're read out in open court. And fourthly, very much linked to the third submission, open justice is not achieved by putting a person who did not attend a trial in the same position as he or she would have been in had they attended the trial. That's the approach of the Court of Appeal in part. It's the submission of my learned friend for Cape, and it isn't right. The court can see how the courts have appreciated the importance of providing access to all documents referred to, whether or not the non-parties attending the trial, through 3 Court of Appeal cases that preceded the landmark judgment of Lord Justice Toulson in Guardian News. And those are Smith-Klein Beecham, Bearings, and Lily Icos. And can I invite the court first to Lord Bingham's judgment in Smith-Klein Beecham and Connaught at page 1178. It starts down at J. I've taken you to the passages from or some of the passages from Lord Scarman's judgment. And can I invite the court, because it's a little bit longer, too long to read, from since the date when Lord Scarman expressed doubt through to the end, please.
So public access to documents referred to in open court, but not in fact read aloud and comprehensively, may be necessary with suitable safeguards to avoid too wide a gap between what has in theory and what has in practice passed into the public domain. That's the sentence you would presumably
That's
emphasise.
one of the two in my yellow bold, my lady. Yes, it was that and between A and B, absolutely. My lady, this theme continues in Bearings and Coopers and Lybrand in the judgment of Lord Wolfe. And here can I invite the court to page 2417. Lady, can we start there, please, at paragraph 41? That's what I would describe as Lord Wolfe raising the issue. And then at paragraph 43, in a paragraph short enough for me to read out, as a matter of basic principle, the starting point should be that practices adopted by the courts and parties to ensure the efficient resolution of litigation should not be allowed to adversely affect the ability of the public to know what is happening in the course of proceedings. And then through to paragraphs 50 to 53. Paragraph 50, so we're at page 2419 to 2420. Paragraph 50, just invite the court to note, that was explaining the slightly narrow approach of Lord Justice Potter to that which Sir Donald Nichols had to say in Dobson and Hastings, which was, as Lord Wolfe describes, accurate, which was that if and when affidavits or other documents are used in open court, their contents will become generally available. And down at paragraph 52, picking it up in the middle, if the transcripts had been read in open court, they would have been in the public domain. If they were read by the judge in or out of court, those are not transcripts at hearing, those are documents, underlying documents. If they were read by the judge in or out of court as part of his responsibility for determining what order should be made, they should be regarded as being in the public domain. Paragraph 53. When documents are put before the court for the purpose of being read in evidence, as here, the onus is no longer on the person contending they've entered the public domain to show this has happened. The onus is on the person contesting this position to show that they did not enter the public domain. And to take it to the end, the judge cannot be cross-examined as to what he has or has not read. And then Lily Icos, which is actually, well, for me it's very close, for you it's just another page number, but it's 2424. And my lady, for these purposes, there's a nice short paragraph, paragraph 9 at the bottom of 2424. The central theme of these rules is the importance of the principle that justice is to be done in public, and within that principle, the importance of those attending a public court understanding the case. They cannot do that if the contents of documents used in that process are concealed from them. And then see the remainder of that paragraph. And paragraph 25 brackets 2 at page 2429, but I don't propose to read it out. My lady, a person attending at court should be able to access documents, and the approach of the Court of Appeal, namely that the non-party should only be put in the position of a person attending the trial, as set out at paragraphs 103 and 107 below, it's page 259. I've got the numbering, but anyway, if you're using the hard copy, it's paragraphs 103 and 107, is with respect flawed. Fifthly, the deployment of a document in support of a litigant's case in open court should be disclosable whether or not it is even read by the trial judge. Otherwise, it is the judiciary which sets the parameters of its jurisdiction to provide disclosure, based no more and no less on the judge's own decision of whether or not to read a given document.
So the least diligent judge will be able to conceal his own lack of diligence.
My lady would invite the most scrutiny. Absolutely. I'm afraid it offends against the principle of transparency. A member of the public is entitled to consider the documents a judge elects not to read, but which have been referred to or relied on, that being a test, as much as those the judge did read. We make that point at paragraph 86 of our written case at page 187, and it receives support from a US case called Lugosz at paragraph 10, and that's at page 4476. So 4476. Paragraph 10, you'll see, for me, it's back at page 4463. We're in the United States Court of Appeals Second Circuit. And in the middle of paragraph 10, there's a quote from an earlier judgment. If the rationale behind access is to allow the public an opportunity to assess the correctness of the judge's decision, documents that the judge should have considered or relied upon but did not are just as deserving of disclosure as those that actually entered into the judge's decision. Now, all of that accords with the test set by 3122 and set by Lord Justice Toulson in the Guardian News case, which, I mean, those tests cannot be read as excluding documents that have been referred to the court, whether or not the court chooses to read them. Lady, this then takes the court to Guardian News. Those were the predecessor key Court of Appeal cases. And can I invite the court to the Guardian News case, which starts at page 1335. And exactly as my Lady Hale says, one has to look very broadly, and it's exactly what Lord Justice Toulson has done in his judgments.
Sorry, could you give me that page number again?
My Lord, yes, it's 1335.
Thank you.
And it starts with the heading introduction in the first words, open justice. And then in the middle between B and C, in a democracy where power depends on the consent of the people governed, the answer must lie in the transparency of the legal process. In short order, I'm going to say that Lord Justice Toulson then went on a tour of domestic cases, not least the 3 Court of Appeal cases I've just taken the court to, and of Commonwealth cases, which are now before the court. They're in our written case, in the intervener's written case, and they're there. And then his conclusions start at paragraph 69. I know you were taken to paragraph 69. It's page 1352, but I must go back there, please. The open justice principle is a constitutional principle to be found not in the written text but in the common law. It is for the courts to determine its requirements, subject to any statutory provision. It follows that the courts have an inherent jurisdiction to determine how the principle should be applied. Para 70. Broadly speaking, the requirements of open justice apply to all tribunals exercising the judicial power of the state. And that language comes, as I say, from Section 32 of the Freedom of Information Act. Paragraph 80 at page 1354. Before dismissing the case of Aaron Waterfield, which Cape relies on in its written case, and which has long since been overtaken by court of appeal authority in this country, he makes the point the practice of the courts is not frozen. And then after paragraph 83, which I don't propose to read out, but which captures much of what I've made in oral submission, paragraph 85, in a case where documents have been placed before a judge and referred to in the course of proceedings, in my judgment, the default position should be that access should be permitted on the open justice principle, and so on. And just because we are in the Guardian News case, and because it's been put to the court orally today that it is significant that we have not relied upon Article 10 rights, can I invite the court over the page to 1356, paragraph 88, and invite the court to read para 88, please. Resurgence of the common law.
Not an ossuary.
My lady, no. And we simply followed the lead given us by Guardian News in our approach from the outset in this case. And my lady, Guardian News presents a roadblock to Cape's case. Hence, Cape's efforts to seek to limit its scope and effect at their paragraphs 61 to 66 on any number of reasons. Criminal case, during the course of trial, amenable judicial review, and so it goes on. Not only can one see the overarching approach that Lord Justice Toulson took in Guardian News, but the roadblock is insuperable to Cape because the approach taken in Guardian News, including that it applies generally to all courts, has been approved by this court in the case of Kennedy.
Before we leave Guardian, I hadn't picked up that Lord Justice Toulson was saying that the principle of open justice would apply to the full trial bundle, which is part of what you want, bundle C, let alone bundle D. What do you say about that?
Bundle D's out, my lord.
Okay.
For these, but we dropped bundle D. It's set out, I'm sure, in our written case that we're simply not pursuing and statement of facts and issues. Bundle D's out.
Yes.
Bundle C, for the avoidance of doubt, see the statement of facts and issues. I'll give you the reference in just one moment, contains trial documents, which I've split in paragraph 1 in our case, to disclosure documents, witness statements, expert reports, and transcripts. Park transcripts for one moment. The disclosure documents and the witness statements and the expert reports were all expressly relied on and referred to by the parties at the trial. That is common ground.
Sorry, when you say disclosure documents, what are they? Is it the full bundle C? Is that what we're talking about?
My Lord, yes, what your Lordship describes as a full bundle C is no more and no less than the documents that the parties, out of an even larger group of documents that they disclosed inter partes,
Yes.
expressly referred to and relied upon at the trial before Mr. Justice Picken.
What, just by virtue of putting them in the
No, my Lord,
bundle?
not so much by virtue of putting them in. They were put in because they were documents that they were referring to and relying upon.
In witness statements or in some other way?
Witness, no. It's paragraph. It's page 99. It's set out in a witness statement from the solicitor for Cape. In relation to our application, it is common ground. It's in the statement of facts and issues. Paragraph 9 starts at page 99. It goes to page 100. And read, please, paragraph 10.
Yeah.
I'll let you.
All right.
I'll let your Lordship read it first.
But paragraph 9 just says contain documents including those referred to in the parties written in oral openings during trial and so on. I have to say I had got the impression that bundle C was a full trial bundle in a commercial action of many volumes of documents. But is that wrong? They were all referred
Well,
to.
my Lord, Yes, my lord. Page 494. Forgive me for asking you to jump around. Paragraph 17. This is the witness statement of Mr. Isted from Freshfields, who was a solicitor for Cape during that trial. Paragraph 17. The core documents identified and relied on during trial were placed in Bundle C, which was split into the PL and the CDL. The intention behind Bundle C was to ensure that the documents being relied upon and put in evidence by the parties at trial were readily available to the parties and trial judge in one place. Bundle C was therefore intended to contain any disclosed documents referred to in court. Lord Justice Hamblin put it to Mr. Jonathan Swift, as he then was. That's documents referred to or relied on, worse effect, isn't it? There's any way around that, and it was pretty much a hands up. That's the position. Those are documents. It's express.
But presumably, Bundle C was put together prospectively, so it's what people were expecting.
Not just prospectively, my lord. Sorry to interrupt, but it was built upon. I think that's...
Yeah, that's explained in the SFI.
Yes, it's explained in the SFI.
But it was updated.
It was updated during the 6-week trial. If someone said, well, actually, can I refer the court to this document? It was extracted from Bundle D, and it was put into Bundle C. There really can be no doubt. We've been as clear as we could be through the statement of facts and issues, which has to be agreed, but we've got the underlying witness statement, that the documents that we're seeking, by which I call disclosure documents, because we're seeking to set out trial documents, at paragraph 1 of our case, my lord, sought to define them for the avoidance of doubt. Does your lordship have that part? That's at page 165. It's para 1 of our case. What are we referring to? Para 1, my lord, if your lordship has that. We've said by trial documents is meant disclosure documents, all of which were filed as part of the trial bundle, I've obviously come to that in due course, and referred to the trial judge and relied on by the parties. And then the witness statements were all filed from witnesses called to give evidence and the experts, and the skeleton arguments obviously were used, and then transcripts were obtained, and they were given to the judge. So they were, it was a live note approach.
I should know the answer to this, but at what stage did the settlement occur? Was it before closing?
After the hearing.
After all.
After the 6-week trial, my lord.
Right.
So, my lord, on that issue, I would please ask the court to accept that there really is no issue, but that paragraph 85 of Lord Justice Toulson's judgment embraces all of the documents which are sought by the applicant here. The one that's closest to the fringes is the daily transcripts. But why would they be put back before the court unless they were being relied on and referred to?
Yes, thank you.
My lord, ladies and my lords, turning to the case of Kennedy, there are two key judgments. It starts at page 1371, but I'll go to express page numbers in a moment, but that's where it starts. There are two key judgments, that of Lord Mance and Lord Toulson. Each of those judges' judgments were agreed with as set out right at the beginning, in parentheses, by Lords Newburger and Clark. Lord Sumption agreed with both of the judgments at paragraph 152, at page 1449, and even the dissenting voices of Lords Wilson and Carnworth did not, so far as one can tell, doubt the Guardian News principle as it applied to courts, query tribunals. And see here Lord Carnworth at paragraph 236, page 1474, and Lord Wilson at para 196 at 1463. And can I then start with the judgment of Lord Mance at page 1420? This was the case in which an application was made under the Freedom of Information Act for a document and it was held by the majority that the document could not be obtained, as it was a court document from the, or tribunal document, from the Freedom of Information Act, but that it could be obtained by making an application under the open justice principle, at least in principle, but that no such
Do
application
you know
was
what
afoot.
happened next?
My lady, I don't. I imagine they've started, and no doubt it will return in due course. So it's a case which is destined to move slowly. It's moved slowly throughout, and so one expects it will get there in the end. Certainly, that was a steer from the Supreme Court. Lady, page 1420, paragraph 47 and into paragraph 48. In the present case, the meaning and significance which are attached to provisions of the Charities Act is, in my view, underpinned by common law presumption in favour of openness in a context such as the present. In this respect, court proceedings and inquiries have more in common with each other than they do with arbitration proceedings between parties who've contracted to resolve issues between them on the well-understood assumption that their proceedings will be private and confidential. Starting with court proceedings, common law principles of open justice have been held to require, and I'll come back to that when we look at the necessity test, if I may, later, to require the disclosure to a newspaper for serious journalistic purposes of documents placed before a judge and referred to in the open court, absent good reason to the contrary. See the Guardian News case. And I'm going to just scan through to paragraph 48. The present appeal concerns not proceedings before a court, but an inquiry conducted by the Charity Commission in relation to a charity. And then I'm just going to take you to a quote, because then I won't have to go back to this, down between E and F. So, albeit in the context of the Charity Commission, we are concerned with a situation where both the Charities Act and the Charity Commission, in publishing its report under the Act, recognise that the public has a legitimate interest in being informed about the relevant inquiries. That must mean properly informed. But it's para 47 in which, certainly on our reading, that is an endorsement of the approach taken to court proceedings. The issue then was whether it would apply further, as Lord Mance held it should, to the inquiry under the Charity Commission. And when one goes to the judgment of Lord Toulson, at paragraph 109, page 1440, right at the bottom at H, subject to any statutory provisions, a judicial body has an inherent jurisdiction to determine its own procedures. See AG and Leveller. The same applies to a public body carrying out a statutory inquiry. And then I'm just going to ask the court to note, because it's too long even to ask the court to read at the moment, that then Lord Toulson sets out that which he determined in his judgment in Guardian News, starting at paragraph 110 and getting through to paragraph 115, when he says the court held in Guardian News that the open justice principle applies, broadly speaking, to all tribunals exercising the judicial power of the state. And then you see the reference as to how that comes from the Freedom of Information Act, which I'll go to in due course. And then over the page, the fundamental reasons for the open justice principle are of general application to any such body, although its practical application may vary according to the nature of the work of a particular judicial body. So that's a fortiori to the courts, because here the majority in the Supreme Court in 2014 are minded to apply it to tribunals, or certainly that tribunal. Lady, those are my submissions in relation to open justice, which will make much shorter of some of the later submissions that I need to make. Can I then turn to the second issue which we set out in our case, and that was the interaction between the inherent jurisdiction of the court and the civil procedure rules. And this is to address that part of Cape's argument to the effect that the invocation of the inherent jurisdiction cuts across, and this is a quote from their grounds at page 20, para 18, cuts across the balance is struck in the CPR between the public interest in access to the court and the open justice principle. And our case in writing, my lady, is set out at paragraphs 25 to 34. That's pages 171 to 173. I'm not going to go to it, but just for the court's record. My lady, the balance drawn between inherent jurisdiction on the one hand and civil procedure rules on the other has been addressed authoritatively in two Supreme Court judgments, that of Lord Dyson in Al-Rari and Lord Toulson in Kennedy. The position is that the court can apply its inherent jurisdiction unless to do so would contravene the civil procedure rules. The test is not, as has been submitted by my learned friend for Cape today, that the court cannot apply its inherent jurisdiction if the civil procedure rule arrangements are justified and proportionate. That is not the test. And in support of that, we were told that it was cases of the highest authority that were being referred to in paragraph 11 of their case, but those were different passage in Al-Rari and Court of Appeal cases. And I'm afraid the position is that which is set out in the Supreme Court. Can I go first to the judgment of Lord Dyson in Al-Rari? So far as concerns the judgment, which starts at page 1233, but I'll go to some specific pages in a moment. Lord Hope agreed with Lord Dyson's judgment. That was at paragraph 76, page 1289. Lord Kerr agreed with his judgment at paragraph 88, page 1293. Now, there's no indication I could find that the other Supreme Court judges disagreed with this approach, but they very much took different paths, including my Lord, Lord Mance, with whom my Lady Hale agreed at page 1296. But I didn't determine or discern from those different paths that they would be minded necessarily to disagree, but I can't say that they have expressly agreed with what Lord Dyson has to say in relation to this particular issue, which we find at page 1286. 1286. It's paragraph 60 and 61 under the heading, The Civil Procedure Rules. And it starts at paragraph 43. The Court of Appeals said that they considered the defendant, this is the closed procedure. Can there be a closed procedure? That the defendants faced very serious difficulties in their contention that the closed material procedure is compatible with the CPR. My lady, can you just kindly go back to page 1251 if it's not too awful to leap around electronically? Because that's para 43. But before that, the court can see para 42, in which the Court of Appeal referenced one of the Court of Appeal cases that's made its way into Cape's grounds of appeal, a case called Raja. So the approach of the Court of Appeal in this case at 43 was an approach which followed the approach set out in Raja and Van Hoogstraten. I'm not going to go down the avenue of exploring those cases. I don't have time, and I don't need to, because when we then go back to page 1286, paragraph 61, I'm not saying to the court, please don't read para 60, but I'm moving apace. Para 61. These points based on the CPR provide some further support for the conclusion I've reached for other reasons. The rules make no provision for a closed procedure, except in circumstances where it's authorised by statute. And of course, it's to the opposite effect in the CPR. On the face of it, the general rules are inconsistent with the closed material procedure, but I do not consider that if the argument based on the CPR stood alone, it would have been sufficient to carry the day for the respondent. It is not sufficiently clear that a closed material procedure would contravene the CPR to say that on that account the court has no power to order such a procedure. And the power is the power and inherent jurisdiction of the court. That's, and I will be going there, but it's paragraphs 18 and following at page 1275, which is headed the inherent power of the court to regulate its own procedure. And I'll be going back to those paragraphs in due course.
Well, it must follow from the view that Lord Manson and I took that we agreed with that sentence, wasn't it?
Then forgive me for not having extracted that sufficiently, but my lady, I certainly, well, I'm pleased if your ladyship says, and I certainly don't see.
Well, I was asking you. I wasn't necessarily saying.
My lady,
it
I thought the highest I could put it was, it is not apparent that there is any conflict. But
well, given that we said that it was okay if the parties agreed to it.
well, your lady, yes, the CPR did not win the day.
No.
This was an attempt to cut back the open justice principle. That's why it didn't succeed, not because there were civil procedure rules which were inconsistent. The point is made to similar effect in a very, very clear way by Lord Toulson. It's actually an echo of one of the passages my learned friends read out from Lord Justice Toulson's judgment in Guardian News, but I take it from the Supreme Court. And I've already referenced the judges who have agreed with the judgment of Lord Toulson and Kennedy. And here it's at page 1442. 1442. There are two paragraphs. And this is actually a contest in relation to the Freedom of Information Act, not the Civil Procedure Rules, but the principle that underlies the position is, of course, the same. And here, Lord Toulson says, as the Court of Appeal said at paragraphs 73 to 74, although the sovereignty of Parliament means that the responsibility of the courts for determining the scope of the open justice principle may be affected by an act of Parliament, Parliament should not be taken to have legislated so as to limit or control the way in which the court decides such a question unless the language of the statute makes it plain beyond possible doubt that this was Parliament's intention. It would therefore be quite wrong to infer from the exclusion of court documents from the Freedom of Information Act that Parliament intended to preclude the court from permitting a non-party to have access to such documents if the court considered such access to be, and I emphasise this word for purposes when we come to the issue of necessity, etc., proper is the description Lord Toulson gives, under the open justice principle. The administrative court's observation, and pausing there I would say, and see Cape's submission, that no good reason had been shown why the checks and balances contained in the Act should be overridden by the common law, that is Cape's submission, was to approach the matter from the wrong direction. The question rather was whether the Act demonstrated unequivocally an intention to preclude the courts from determining in a particular case how the open justice system should be applied. Pretty clear, and it knocks out completely Cape's submission. Lady, can I then turn to the third issue, which is cross-appeal ground one. It's the scope of the Civil Procedure Rule 5.4c2. Lady, much of Cape's argument is centred on how the open justice principle is honoured through the civil procedure rules. And our primary case is just so. And CPR 5.4c2, properly interpreted, provides the route by which the trial documents, that's as defined in para 1 of our case, can be obtained by a non-party from the court at any stage, whether during or after trial, subject always to the court choosing to exercise its undoubted discretion in the applicant's favour. And our primary submission is that the key is in filing of documents at court. In support of that, may I make 6 submissions. First is, that accords with the plain reading of 5.4 C2. And can we go back, please, to the rule? It's at page 1642. At the top, 5.4c. And 5.4c1 says the general rule is that a person who's not a party to proceedings may obtain from the court records a copy of A, a statement of case, etc., and B, a judgment or order given or made in public. Court records obviously include court orders. Hence the use of a generic set of words, court records, because it is not only documents filed at court, but it includes documents produced by court. 5.4c2, a non-party may, if the court gives permission, obtain from the records of the court, and it was, I think, submitted today that means it's not obtained from the court. They're obtained from the court, but from the court's records. From the records of the court, a copy of any other document filed by a party or communication between a court and a party or another person. Filing, you've heard, it's at page 1603, Civil Procedure Rules 2.3, is defined in relation to a document as delivering it by post or otherwise to the court office. So there is a rule which on its face would suggest that records of the court will embrace judgments or orders, in other words, documents which are promulgated and produced by the court, as one would expect, and also any other document, in no way constrained, provided it is filed by a party, and additionally, or communication between a court and a party, and I'll come back to that later if I may. Second submission, my lady, is that it's consistent with and accords with a reading of 5.4c2 in the full context of CPR 5. And can I here invite the court to the previous page, 1641. 5.4b. 5.4b1. A party to proceedings may, unless the court orders otherwise, obtain from the records of the court a copy of any document listed in para 4.2a of PD 5a, from which it follows, and I'll go to it in a moment, that all the documents in paragraph 4.2a of PD 5a are records of the court. From 5.4b2...
Does it follow?
Yes, my lady. It must follow. I believe that even to be common ground with Kate. Not that, that means it's right. If we agree, we could both be wrong. But, my lady, it's...
The words that I imagine would be relied on for a counter-argument would be from the records of the court. So that only those documents listed or described, either listed in the practice direction or described as being filed, only those of them which are in the records of the court are disclosable.
My lady, this is the... I mean, not in relation to that. The Court of Appeal did not identify that as an argument against...
No, I'm identifying it.
Absolutely. But they did identify or take a similar approach. I will come next to a purposive reading, because that's sort of purposefully narrow reading that your ladyship is testing me with. But, my lady, a natural reading of this provision is, unless one has in one's mind that there is this records of the court thing that exists, that we've somehow additionally got to get into, but no one's going to tell me what it is. It's not defined. You won't find court records means the following in the civil procedure rules. So it then becomes somewhat mystical. And we're then faced with, well, are we or aren't we? We don't know, because we don't know what the court records are. And that is unsatisfactory, to say the least. My lady, on this ordinary interpretation, we know what the court records are. They are documents produced or promulgated by the court and documents filed at court or communications between a party or another person and the court.
Will you presumably accept for as long as they're held by the court?
That comes to the whole practical issue, which I will touch upon in due course. But the expansion and contraction of court records is nothing new. Whether they contract because it's been determined that the court records can be disposed of within days or years, there is an ordinary expansion and contraction of court records. There's not a point against us. My lady, the second point of just...
Sorry, can I just ask?
Yes, my
Did
lord.
Bundle C then become, according to your argument,
Yes, my
part of the court record as soon as it was delivered to the court office?
Yes, my lord. And we so set that out in our case, and we don't accept that we were in agreement with what was said to be a sort of concession that the open justice principle doesn't bite at all until the documents are deployed in open court. That's not our case as set out in writing. That's paragraph 44 of our case at pages 176 to 177. I'm going to touch upon it later. Before I go to the practice direction, just so I don't have to go back to this, my lady, I'm at page 1641, I'm at 5.4b, and your ladyship can see, 2, a party to proceedings may, if the court gives permission, obtain from the records of the court a copy of any other document filed by a party or communication between the court and the party or another person, from which I simply draw at this stage that the list of documents in paragraph 4.2a of PD 5a is not exhaustive. Now, lady, can I then ask the court to go to the practice direction, please? And that's at page 1646. And 4.2a at 1646, which is more than halfway down, says a party to proceedings may, unless the court orders otherwise, obtain from the records of the court a copy of, and you'll see a number of documents there. Going over to page I, any written evidence filed in relation to an application. My lady, the Court of Appeal at paragraph 40, which is at page 238, accepted that one might expect records of the court to extend to, words of Lord Justice Hamblin, documents of an analogous nature, paragraph 40. What could be more analogous to written evidence filed in relation to an application than written evidence filed in relation to a trial? And how can it be that we're in a situation where court records will subsume written evidence filed in relation to an application, however modest the scope of the application, but not written evidence filed in relation to the real issue on which the court is being asked to administer its justice and determine at a trial? Describe that as a paradox in our written case. My lady, thirdly, this is all in support of why 5.4c2 provides a jurisdictional access to these documents. We would invite the court to undertake a purposive reading in accordance with the principle of open justice. We don't believe it to be an issue, because it's all part of Cape's case, that 5.4c2 furthers the principle of open justice. And it follows that on a purposive reading of this provision, the court should be striving to further, not limit, the principle. My lady, filing is key precisely because it is on filing that this, I say here the civil, we are in a civil procedural, my lady, this is for civil procedure. that the civil justice system is engaged. When you have disclosure between parties, that is communication of documents between the parties. But when you file something like a document, you are engaging the civil justice system. That is why the filing of a statement of case itself triggers the open justice principle. It led, based upon that argument by the media, to the insertion of 5.4c1. The general rule is that a person who is not a party to proceedings may obtain from the court records a copy of the statement of case. And you do not need to wait for judicial action. You need to wait, I think, for an acknowledgement of service. But you do not need judicial involvement, as in actual judicial determination of an issue, because that is a document filed with the court, as in the organ of the state.
But by the same token, so would the documents filed with it be? And yet the maker of the rule with the statement of case.
My Lord, just so, and that goes simply to highlight how, and this is no criticism of the civil procedure rules, how the civil procedure rules grow and develop, in parts depending upon who presses at which point and so on and so forth. And the media pressed at one point and they got what they asked for. The idea, and this, as I say, is absolutely no criticism of the Civil Procedure Rules Committee's unenviable task, but the idea that the Civil Procedure Rules provide a complete code is not one which accords with reality, and it's not one which accords with the case law of the Supreme Court. See our rari, to which I will take the court in due course. It simply isn't right. My lady, in the Attorney General Leveller case, to which the court has already seen a number of references, Lord Diplock observed, and this is at page 1077b, at B, the application of this principle, that's the principle of open justice, has two aspects. As respects proceedings in the court itself, it requires that they should be held in open court, to which the press and public are admitted, and that in criminal cases at any rate, all evidence communicated to the court is communicated publicly. And my lady, that chimes precisely with 5.4c2 in relation to the or communication between a court and a party or another person. Because filed documents and other communications with the court are communicated publicly. And so the court should enjoy a jurisdiction to provide copies of such documents. And lady, I would add that it's not obvious that CAPE is pursuing a sort of pepper and heart type argument that the proper interpretation of the CPR is to be divined by reference to what's contained in the minutes of the meetings of the CPRC, although much attention is devoted to them. But in any event, there is nothing in the Civil Procedure Rules documentation which sets out in terms that trial documents are not covered by 5.4c2. There isn't a sentence that says trial documents are covered. There is not a sentence that says trial documents aren't covered. What there is, in a report chaired by Mr. Justice Jackson in 2008, is a recognition, it's at page 3873, at 4.2, the bottom part of 4.2, that skeleton arguments filed pursuant to paragraph 5.9 of 52 practice direction currently fall within the right to apply regime under 5.4c2. So this is the CPRC saying, we've noted the case of Geo, C4.1 above, and the invocation of the inherent jurisdiction of the court. We would like to bring that within a rule. 4.1. One of the rules provides for skeleton arguments to be filed, and those are covered by 5.4c2 because they're filed. Simple as that. My lady, the fourth submission in support of our proposed interpretation of 5.4c2 is to invite the court to read the civil procedure rules against the backdrop of the Freedom of Information Act. And now I'm going to go to section 32, which is at page 3421. My lady. And my learned friend for Cape has already noted that paragraph, section 32 is headed court records, comma, etc. That's for good reason, my lady, because when your ladyship goes down to 32.2, it says information held by public authorities exempt if it's held only by virtue of being contained in any document placed in the custody of a person conducting an inquiry or arbitration for the purposes of the inquiry or arbitration. In other words, a setting that's not a court record, but is similar to or comparable to a court record. But when it comes to the court, see section 32.1, information held by public authorities exempt information if it's held only by virtue of being contained in A, any document filed with or otherwise placed in the custody of a court for the purposes of proceedings in a particular cause or matter. And then you see the definition at 32.4a, court includes any tribunal or body exercising the judicial power of the state, which I've referred to earlier. So that the proposed interpretation of court records of the forum is entirely of a piece with that which is set out by Parliament at section 32 headed and section 32.1a. And the etc. Plainly relates to inquiries or arbitrations. In other words, see section 4a, court includes any tribunal or body, etc. My lady, fifthly, the proposed interpretation.
So 4 was your Freedom of Information Act consistency point.
Yes, it was. I didn't read them all out at the beginning just to save time and keep you in a state of suspense, my lady. But yes.
There's always a point when I make a note of any council's submissions that I lose count. But
lady,
I've now got
I
have got 4.
We're
now
there.
I've got 5.
We're there.
Yes.
We're on point 5, my lady. Only 2 to go. The reading of the civil procedure rules set against its historical backdrop, which is short form, is that there has been a right of long standing to apply for what I will call trial documents. They don't put it in those terms, but in other words, documents produced by a party which are relied upon in a judicial determination. Now this we set out, and I hope accurately, as a sort of process of legal archaeology, and whether it will be overridden by further inquiries by the court or not, I hope we have it as it is. Paragraphs 51 to 62 of our case, which is pages 178 to 181. And I'm going to start back with a reference to the Act of 1372 in short form, and make this submission. It would appear that in 1372, an Act of Parliament recognised that, open inverted commas, all judicial records, close inverted commas, were open to the public, albeit a person needed to show standing by way of the records touching them in some manner. Now that does immediately beg the question what's meant by judicial records. And whilst we don't have a full-on answer to that, it would appear, first of all, from the Caddy and Barlow cases, and which we'll take the court to in a moment, that it will include documents created by the parties because that related to an indictment. An indictment is created by the prosecution, not the court. So that is a document created by one of the parties, and that was a document that the acquitted individual was held to be entitled to. It would also appear from the fact that the reference to the 1372 Act is made in both the Canadian case of McIntyre and the US Supreme Court case of Nixon, both of which concerned documents created by the parties, that it was properly understood as being a case which covered such documents. I'm not going to go to the references in McIntyre and Nixon for want of time, but they're all in our written case. But I will invite the court just to have a look at the decision in Caddy and Barlow, which we've quoted the relevant part of in our case at page 179, but the case itself is at 1979. There are three cases which follow each other. We'll just pick out one. And this is one of three cases in which the acquitted individual was given access to the indictment against him. And on page 1979, you'll see the reference underneath rule refused, left-hand column. It appears that originally all judicial records, and that's where I get that from, of the King's Courts were open to the public without restraint. And as you run down the bottom of that column, and then through the next column, you'll see it says, of whatever record touches them in any manner. And that was the standing that was required. You needed to be touched at that time.
Well, you would share the view that they contain great and hidden treasure.
My lady, yes.
Which is why you want them.
Absolutely. It's the case, and we do. Lady, can I then go to Holdsworth, Volume 5, at page 5101.
Sorry, can you give me that page again?
Yes, my lord, it's 5101.
Yeah.
I'm in Holdsworth, 1924, Volume 5, which explains at page 5101, under the heading Reports and Certificates. These are a collection of reports made by the masters from 1544 to the abolition of the masters in 1848. After that date, their place is taken by the reports of the chief clerks and taxing masters, etc. And down at the bottom, thus we get decree rolls on which were entered all such decrees as were solemnly enrolled, registrar's court or minute books, consisting of notes taken in court by the registrar of minutes of the court's decision, and chancery masters' documents consisting of affidavits, accounts, and other evidence on which they grounded their reports. Now, those chancery masters were abolished, as we see, in 1848, and we have the relevant rules prior to their abolition in 1834, which are to be found at page 3479. And you'll see on that page that these are the practice of the High Court of Chancery, and you'll see it says, as altered by the Chancery Regulation Act 3 and 4, William IV, C94. I'll come back to that if I may.
Tomorrow, I think.
I'll come back to that tomorrow, if I may, my lady.
You've got another minute if you'd like to.
Well, I will plough
Reach a
on.
convenient
Oh, absolutely.
point.
I'll take as much as I can. My lady, if you then go to page 3490, we're in Rule 30, or Order 30, and second sub-paragraph near the top, that proper calendars or index should be kept by the clerks, and such calendars or index in the books of entries shall be accessible to the public on payment of the usual fee, and two sub-paragraphs down, that proper indexes or calendars to the files or bundles of the reports and exceptions to reports and petitions should be kept so that the same may be conveniently referred to and required, and such calendars and indexes and the said original reports, those masters' reports, and exceptions to reports and petitions shall at all times during office hours be accessible to the public on payment of the usual fees. And if you kindly go to page 3497, you can pay 2 shillings and 6pence for every exhibit, this is down near the bottom, proved viva voce in court. Does your ladyship have that? It's about 3/4 of the way down, which we rely upon as showing that this was documentary evidence. And it's set out perhaps a little bit more clearly when you again turn over to page 3499, to the 1859 Consolidated General Orders of the High Court of Chancery, and then to page 3502, near the top, so 3502, near the top, as your ladyship see, it says the custody of exhibits deposited for inspecting and copying, and then to similar effect, we have what then becomes Rule 46 at page 3504. So Rule 46 right at the bottom of 3504. Proper indexes or calendars to the files or bundles of the reports, certificates, exceptions, reports, petitions, admissions of evidence, and all other documents filed at the report office shall be kept by the clerks of the records and writs, so that the same may be conveniently referred to when required, and such indexes or calendars and documents shall at all times during office hours be accessible to the public on payment of the usual fee. And I'll end, if I may, just by going to 3508. Now we're not doing it viva voce, now down towards the bottom. Price has gone up. And you'll see upon every application to inspect exhibits, if occupied, not more than 1 hour. My lady, may I continue that journey tomorrow morning?
Indeed. That is undoubtedly a suitable moment at which to adjourn.